Breaking news out of the United States District Court for the Eastern District of Washington. In contrast to Judge Roger Benitez, who got it right when it comes to magazine bans under the Second Amendment, Judge Mary Dimke in Washington State did not get it right. We're going to talk about where she went wrong and how that happened when we get right back. Hey folks, I'm Mark Smith, host of the 4 Box of Dine, a proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of First They Came for the Gun Owners, the A to Z guide of how the anti-gunners are trying to take away our guns. Check it out. It's also available on Audible and on Kindle. Okay, so Judge Mary Dimke in the United States District Court for the Eastern District of Washington, a case of Brombeck versus Ferguson, has denied a request for a preliminary injunction to enjoin Washington State's ban on purchasing and acquiring magazines that hold more than 10 rounds. Now, I just want to say before we get into the details of the decision here, a little bit of background about the Judge Mary Dimke. She's a Joe Biden pick, but I took a look at her background, and she's the classic kind of lawyer. At some point, I'm going to do a video on lawyers, how to understand where they come from, but we won't do that in this video here. But she is a career government employee. She graduated from law school. She went to work for a couple judges. That's perfectly fine and actually prestigious. But then she immediately went in to work for the Department of Justice and spent her entire career from law school going to work for judges for the government, and then working as an attorney for the government, and then became a magistrate judge and now a federal district court judge. Her entire career is working for law and order government. So her bias, and it's pretty clear when you look at her opinion, she is pro-government, government powers, the way she writes this, and she's not sophisticated in the ways of constitutional law. You can sort of tell that by how she kind of mouths the right words, she quotes the right parts of Heller and Bruin and proper language, but then somehow it goes off the rails when she actually tries to take the law she quotes and actually use it. And that's not super unusual with people that spend their entire career working for the government, because the truth is, most lawyers that work for the government, it's not that stressful. And if you got a bad case or bad facts or something that's not working out in your best interest, you find a way to get rid of the case, either by plea bargaining it, dropping it, settling something, because you have all the cards, because you're working for the United States government. That's much better than like private attorneys that often have to take cases that are losers and try to turn them into winners. Much more difficult and much more intellectually rigorous. I don't think that there's anything in Judge Dimke's background here that would suggest to me intellectual rigor. We'll just leave it at that. But let's go on and see how she did. Well, to begin with, I want to say that one of my predictions has already proven true. That is, a couple weeks ago, I said that this really important Ninth Circuit Court of Appeals decision called Baird versus Bonta, or Baird versus Bonta, from September 7th, dealing with preliminary injunction standards, was going to be a big deal. It was going to be the new standard, and it was going to force judges to laser focus on whether or not it was likely that a government law violated the right to keep and bear arms under the Second Amendment. And indeed, my prediction is already proven true, that even though this motion for a preliminary injunction was denied by Judge Dimke here, and probably wrongly so, but we'll get to that in a second, she's immediately, first thing right out of the gate, is quoting and citing to Baird of the Ninth Circuit as the relevant law for these Second Amendment cases dealing with preliminary injunctions. So I think that's a very good sign that that helpful case is already being used, even in cases where the Second Amendment loses. But once she starts off on a positive note like that, Judge Dimke's opinion quickly goes off the rails. Let me just read these two sentences to you on pages 6 and 7 of her opinion, and you'll see the inconsistency immediately. So she says, the question before the court at this stage is not, as plaintiffs assert, whether the relevant statute in Washington state and its effective amendments impairs or infringes upon the right of Washington citizens to keep and or bear arms. What? Hello? What? It's a Second Amendment challenge. How is the question before this court anything other than whether or not this Washington state law infringes upon the right of Washington citizens to keep and bear arms? Well, that's what she wrote. She literally wrote that. Then she goes on to say, the real question, and here's where you know she's going off the rails. Not intellectually rigorous in any respect. You'll see it right here. Next sentence says this. The question before the court is whether plaintiffs have made the requisite showing under the relevant standard. Okay. Well, what is the relevant standard? The relevant standard has 4 parts under the Bayer test. And what is part 1? Part 1 is, does the gun control law, violate or impair someone's right to keep and bear arms? That sounds a whole lot like the question before the court at this stage is, in fact, yes. Does this Washington gun law violate the Second Amendment of people that live in Washington? That's exactly what this is about. So you can immediately see that intellectually, just with those 2 sentences juxtaposed against one another, she's immediately off the rail because it's totally wrong. Because by definition, you can't decide a preliminary injunction unless you first and foremost ask the question of whether or not that injunction, whether the plaintiffs are likely to succeed on the merits. And when the question presented is a Second Amendment question, the question is whether or not the plaintiff is likely to succeed on the merits of the Second Amendment, i.e., does the gun control law being challenged likely violate the plaintiff's individual right to keep and bear arms under the Second Amendment? So yes, of course, the standard that she's applying does indeed have to ask the specific question of, does the law violate the Second Amendment? Of course it does. That's the entire job that Judge Dimke has been asked to do here. So you can see where this is starting to go. Sloppy. Then she goes on and makes another typical mistake that we see. And now whether or not these are mistakes or she's confused or doesn't want to understand, I can't speak to that. I've never met the woman. I can only infer from her background of what she's done in her career. With that said, she immediately starts talking about Bruin. The court articulated, the Supreme Court articulated a test for Second Amendment challenge to firearm regulations. And then she quotes the Bruin standard, which of course text first and then history second. Okay, that's fine. But what's the issue here? This is a ban, right? This is a ban on the acquisition, the buying and selling, acquiring of magazines more than 10 rounds. It is a gun ban or arms ban case. When it is an arms ban case, you're dealing not with Bruin as the precedent that's to be applied. You're dealing with Heller. Heller is the guiding principle. Heller is the law of the land. But here she is immediately jumping right into the deep end with Bruin when you're dealing with an arms ban case. So she's already going down the wrong path right there on page 8 of her opinion. But let us continue on. She then talks about, and this is where she really gets really screwed up. She conflates, so again, she lays out the test sort of okay. She says, you start with the text of the Second Amendment, and then as defined by the Supreme Court, that's the text, okay? Then she goes on to say, and then of course, the burden shifts to the government to use history to show there's a traditional historical regulation or ban or whatever it is that's consistent with the modern day gun control law that's being challenged. So she articulates that standard's okay, but here's the problem. She immediately starts to conflate historical concepts with textual concepts. She immediately starts to conflate and blend the 2 types of analysis as opposed to treating them separately. Now, this is a classic maneuver that the anti-gunners always try to dupe judges with. What they try to do is they try to conflate the textual analysis of a problem involving the Second Amendment with the historical analysis component of the Second Amendment. And we know why they do that. Because once the text is defined in such a way that shows that the modern day gun control law is implicated by or touches fingers with or violates the text of the Second Amendment, we know what happens. What happens is something extremely bad for the government. What happens when the text is implicated, the text of the Second Amendment is implicated by modern day gun control law, the burden shifts. The burden shifts in a huge way to the government. The government then bears the burden to show by using historical analog laws at the time of the founding that the modern day gun control law was the sort of thing that our founders would and did have on the books. So what happens is, to avoid the government having to bear that burden, they anyone that doesn't like guns, the anti-gunners all try to pretend that all the fights and all the battles occur at the textual level because the government never, ever, ever wants that burden to shift to the government because it makes the jobs of the government almost impossible to win, and they hate that. So what happens here with Judge Dimke is she does exactly that. She immediately embraces the arguments that the phrase dangerous and unusual, military-style weapons and all this stuff, somehow implicates the text. You see what I just said? Her argument is that to understand what the text of the Second Amendment means, such as whether or not what does arms mean, are magazines arms, this sort of thing, she says you have to get into issues of dangerous and unusual, military-style weapons, things like this. But that's not true because the text of the Second Amendment is quite clear. The right of the people to keep and bear arms shall not be infringed. For the purposes of this discussion with magazines, she laser focused on arms. Now, arms, and again, she defines arms properly using Supreme Court precedent because she does say, in her opinion, that arms are anything that can be used offensively or defensively, which is true. But then she goes on to say, and this is crazy that she said this, she says that a magazine is a part of a firearm, but on its own, it cannot be used to attack or defend. Did you hear what I just said? She says that a magazine is a part of a firearm, and on its own, it cannot be used to attack or defend, i.e., it cannot be used offensively or defensively. That's her argument. Now, this is insane, because think about what that would mean. That would mean that a barrel could be banned, because a barrel on its own, although I suppose you could hit somebody over the head with a barrel, but a barrel on its own is just a pipe, right? A trigger on its own is not a weapon. A spring that goes into the magazine, or a spring, or a firing pin, or a handle, right? Or the revolving chambers of a revolver, any of these things, right, are in and of themselves not something that can be used to attack or defend oneself. And yet, according to Judge Dimke, that is what the question is. Because a magazine is a part of a firearm and not in and of itself something can be used to defend or offend or attack or defend against, it is not an arm. But what's really strange here is that she quotes the right language, believe it or not, that shows that is simply an absurd argument, because she quotes Clarence Thomas talking about how, ready, you're gonna appreciate this. Quote, this is Clarence Thomas. She quotes this. This goes back to my point that she mouths the right words. She says the right stuff. But then when it comes to actually the hard part of being a lawyer and a judge, which is to mouth the words of the law and then actually use it effectively and accurately, that second part's the hard part. Well, that's where she goes off the rails. So she quotes Clarence Thomas correctly in the Lewis versus the United States case. This is what she says, quoting the Supreme Court of Clarence Thomas. Quote, constitutional rights thus implicitly protect those closely related acts necessary to their exercise. You see that? That's what she says. Closely related to their exercise. The other thing she goes on to say, she quotes several cases, including cases from the Ninth Circuit, that specifically say, quote, the Second Amendment protects ancillary rights necessary to the realization of the core right to possess a firearm for self-defense. Goes on, she quotes, the Ninth Circuit has previously presumed that the right to possess a firearm includes the right to purchase one. And of course, there's the discussion that says that the right to keep and bear arms would not mean much if you don't have the right to acquire it in the first place. So again, she cites to all the cases that say that things by implication fall within the scope of the Second Amendment, but then she gets it all wrong, because all she needed to do was to say, look, a magazine is obviously an essential part of a firearm. That is why Washington State is trying to ban and or regulate and or stop them on their firearms laws, right? Magazines are not being defined in some, electricity code. It's part of the Washington State firearms related code because it relates to firearms. It's so related to firearms, it falls within that part of the statute of Washington State. So that's obviously part of why it's a magazine. But then you go on, you realize obviously an essential part to a modern day firearms. And we know both from Heller and we know from Caetano, which she also cites too. She even cites that the stun guns and that a few 100,000, stun guns basically made it in common use. So she says all this stuff and she acknowledges all this, but then for some reason cannot connect the dots that a magazine is part of an arm, and thus is a protected arm under the Second Amendment. She says she can't conclude that textually. She needs a bunch of historical evidence. But if you look at Heller, Heller defines what an arm is not using historical evidence. It's basically used in definitions at the time of the founding that the Supreme Court has already given to Judge Dimke, and these necessary implication things that is very standard throughout constitutional law. Again, the Minneapolis Star cases we've talked about before involved an unconstitutional tax on ink that violated the First Amendment's right to free speech and right to free press. So here you have a tax on ink. Now, the word ink does not appear in the Constitution. The word ink does not appear in the First Amendment. And yet the Supreme Court obviously said, well, ink, pens, printing presses, phones, cell phones, computers, these are all things that facilitate the right to keep the right of free speech and the right to a free press. So therefore, they're protected under the First Amendment. So too, of course, are magazines. And she cites to all the relevant law, but then applies it improperly. And then to make things even crazier, on page 16 of her opinion, she actually admits that bullets do not appear in the text of the Second Amendment, and yet they're protected by the Second Amendment. She writes on page 16, the Ninth Circuit had elsewhere found that without bullets, the right to bear arms would be meaningless. A regulation eliminating a person's ability to obtain or use ammunition could thereby make it impossible to use firearms for their core purpose. Well, how are magazines and bullets any different for the purposes of what constitutes an arm at the textual level? Obviously, magazines are an arm for the purposes of the textual level. And because it's an arm at the textual level, the burden should have shifted to the government to say, where is the historical evidence at the time of the founding that you could ban any kind of an arm at all at the time of the founding? The answer is that does not exist. We know it doesn't exist. Do you know why we know it doesn't exist? We know it doesn't exist because there's a court in America that had previously already done the textual and the historical work of arms ban cases. And it's called the United States Supreme Court in the case of Heller versus DC. And they said that indeed that a ban on any kind of an arm is unconstitutional under the Second Amendment if that arm is in common use by Americans for lawful purposes. And why is that? Because the historical analogs that the Supreme Court looked at and discussed in Heller taught us that the only kind of arms that could conceivably be banned at the time of the founding, the only possible arms that even have any chance of being banned, are those that are both dangerous and unusual. And if they're in common use, such magazines undeniably are, they are obviously not unusual. So therefore, you can't ban them because they're not dangerous and unusual because they're not unusual because they're common. So that's pretty straightforward analysis. But then she goes on to say that, and this is her final error, and I don't want to belabor this point, but she confuses legislative facts with adjudicatory facts. Okay, so let me cut to the chase here. In Heller and in Bruin, the Supreme Court made a bunch of discussions and decisions about firearms in common use, stun guns in common use in Caetano. And did you know in Heller, Bruin, and in Caetano, there was no trial on the question of common use of firearms? There was no discussion or trial about how many times people pulled a trigger, or how many people shot a stun gun. There was no expert testimony taken in any of those three cases about firearms technology. There was none of that. None of that. No experts, no testimony, no evidence. None of that was necessary because the issues presented were what are known as legislative facts, which are basically facts about the world around us that you don't have to actually put evidence on. So, for example, if you want to sort of say that the world is round, you don't have to put on expert testimony to establish that. That's just kind of established known facts. Information about firearms, the common use of them, this is all understood. It's ubiquitous, and that's not me talking, it's the Supreme Court, because the Supreme Court has issued 4 major Second Amendment cases all without trials on firearms technology, all without trials on how many guns were used or when they're used or how they're used in Heller, McDonald, Bruin, and Catano. So here you have a judge, in contrast, Judge Dimke, that's talking about how, oh, well, I really need a lot more evidence. I need to have a hearing. She says that, oh, there's just conclusory affidavits, and I need to have testimony. I might need historical evidence, blah, blah, blah. None of this is true, because if the Supreme Court didn't need it to decide those 4 big Second Amendment cases, why does Judge Dimke need it? The answer is she simply does not. Now, she may not understand this. I have a feeling this will all get fixed over time. Nevertheless, she denied the motion for preliminary injunction because she said the plaintiffs had not established their burden. The reality was the plaintiffs already established their burden. They only had to show that the text was implicated in the Second Amendment, and that just required a showing that magazines are arms, which they are, for the reasons we've talked about and the reasons why many other courts have said they're arms. And then the burden would have shifted to the government to come forth to show historical analog, specifically that these magazines are not in common use. They never could have done it, and the plaintiffs should have won this injunction. But Judge Dimke basically says, well, everything's in flux. It's a little confusing. I need to think harder about this. This is a really big deal. So basically, she basically just begged off the question, dragged her feet, and denied the injunction. But we'll see what happens, because they could take an emergency appeal to the Ninth Circuit, and it could go up at the same time that Ninth Circuit is hearing the emergency appeal from Judge Benitez's big win for the Second Amendment. So it all may get up there together, Washington State and the state of California, all in front of that same panel. We will see. I'll keep you abreast as these things develop. But if I were the plaintiffs in this case, I would probably seek an emergency appeal to the Ninth Circuit and see if I could glom on to that emergency appeal from Gavin Newsom out of California involving the Judge Benitez case. All right, folks, hope you learned a little bit something here today. If you haven't subscribed, please do so, and we'll see you again soon at the Four Boxes Diner.